had
that there was incapacity.
There was complete incapacity. I don't know if it's not diminished, it's complete incapacity. Therefore, stay patient sort of thing. And then going down to the maybe mitigation.
Yeah, in fact, it can go all the way down to disagreeing that there was any impact of it and that the evidence should be
Okay, so if we can just
dismissed.
go through those.
Sure.
What's your answer?
Me?
Yeah.
Okay. So I just need to unpack those basically.
Sure, just let me know because I was just about to say I put my different hats on and I'm back in my lecturer hat. So just let me know if I need to say things quicker and shorten that. Okay.
Are you okay, Mario?
Yeah, let's go.
Okay. Kelly, Pistorius he's having his psychiatric observation. This will be run on the night before we probably go to court. What happens next once that's completed?
Well, there's 3 potential outcomes as a result of the psychiatric evaluation. Either the psychiatrists come back and their report suggests that on the night in question, when the conduct was committed, that he was suffering from a mental illness, from GAD, and that rendered him incapable. And essentially what that means is that he didn't have the ability for insight to determine the difference between right and wrong, or the ability for self-control to act in accordance with that understanding of the difference between right and wrong. That would be a very extreme outcome, and in fact very unusual considering that Mr. Nell was the person who ordered this evaluation, because that would result in an automatic verdict of not guilty by reason of mental illness. And essentially what would have happened there is that you would have had a prosecutor successfully arguing the defense of incapacity, resulting in a verdict of not guilty. It is unlikely that that will be the outcome because we've heard both Nell and Rue argue that they don't believe that Mr. Pistorius was incapacitated on the night in question. The second, less extreme outcome is that their report essentially confirms Merrill Foster's testimony. So he has a mental illness that does have some impact on his capacity. He has diminished capacity, but it didn't completely eviscerate his capacity. Now, if that is the finding, first of all, it makes Merrill Foster's evidence more persuasive in the eyes of the court. Secondly, it means that his mental illness or mental condition can be taken into account in determining his defense of putative private defense. And lastly, it would certainly be a mitigating factor should he be convicted at the sentencing stage. The third potential outcome is that they come back and they substantially disagree with Merrill Foster, either that he was suffering from generalized anxiety disorder, or that generalized anxiety disorder has any relevance, any bearing on understanding his conduct and his frame of mind on the night in question. That would be a success for the prosecution because they will then have succeeded in downgrading the persuasive value of Merrill Foster's evidence. Having said that, we also have to remember that all of these 3 scenarios are assuming that the report is unanimous. If the report is not unanimous, if the different psychiatrists and the psychologist on the panel disagree with each other, then that could add some time to the trial, because in that case, if the report isn't unanimous, or if the defense or prosecution object to the report, then the members of the panel can be called to the court to give testimony, to give evidence as witnesses in court, and can be subject to examination and cross-examination for the judge to determine which of the versions of the report or of the evaluation are the most reliable and therefore should be accepted by the court.
Fantastic.
Was that okay?
You're a bombshell. Okay. One other question was, what actually happens physically? The report, once the observation is done, the report gets compiled, it gets taken by who to court, then what happens to it?
Once the report has been compiled, the prosecutor's psychiatric representative needs to deliver that report to court into the hands of the judge's clerk or the court registrar. It will be the clerk in this case. And from the time that that order has been obtained by the clerk and has been given to the judge, it is essentially considered a part of the court record. Now, the rules of evidence in South African criminal law require that for evidence to form part of a court record, it needs to be admitted in court and essentially testified to a witness in order to get it admitted to the record. So it may be that on Monday, the findings of the report are read through in court in order for it to be formally admitted to the court record. But usually where it's a unanimous report, this is not necessarily a particularly lengthy or complex process.
Okay, brilliant. And just in terms of the state of play at the moment, this may throw you, so if it does, then we don't have to do it.
No
I just want to keep it for my records.
Sure.
The state of play at the moment, how do you think each side has acquitted themselves, state and prosecution?
I think it's very difficult to evaluate that at this point because, in fairness, one has to approach a criminal trial the way that a judge would approach a criminal trial. And that is that a determination is made on an evaluation of all of the evidence presented. We've seen all of the state's evidence. We haven't yet seen all of the defense's evidence. So we aren't really in a position to weigh the two up against each other. We can look at individual moments in the trial and say, do we think those moments went well or went poorly for the party that was presenting it? But we don't yet know what the general impact of that moment will be on the outcome of the trial, because each moment gets considered in its own light, but it then gets considered in the light of how it relates to all of the other evidence that's been presented. And until all of that evidence has been presented, we can't really know yet if missteps have been taken. So, for example, to give you a tangible example, there may be moments in Pistorius's testimony that appeared to be strange, an anomaly. So one thing that many people commented on was his seeming unwillingness, for example, in the Tasha's gun incident, to acknowledge that he was the person who pulled the trigger. He kept saying the gun went off. He said he had the gun in his hand, but he wouldn't be drawn into saying he pulled the trigger. And people criticized him for that, saying that that came across as obstructive and belligerent and uncooperative. And that may well end up being the case, but we actually don't know that yet, because we don't know if the defense has another witness that they are putting on the stand that explains that moment in that incident, and that Pistorius just spoke up to the point that he was capable of speaking up to, and another expert witness will then explain what could have happened with that firearm if he hadn't pulled the trigger. So if that happens, then it's no longer an anomaly. If it didn't happen, then it remains an anomaly and perhaps could be negative for his case.
Super, thank you. Can we just get, he shouldn't have pleaded, his bail explanation shouldn't have come so early on.
He shouldn't have given so much detail.
Exactly.
Yeah.
And also,
In fairness, Nell argued that,
Yeah.
right? So Nell forced him into that corner. He wasn't arguing that the GAD led him into a great plea, that he thought what he says he was thinking on that night.
Okay.
So in other words, he's saying, his version is essentially, I was paranoid about...
Arguing diminished capacity.
They're not arguing incapacity. Diminished capacity is a colloquialism for the legal version. Section 78, the referral, is the flip side of that defense, which is called pathological incapacity, which is where the incapacity was caused by a recognized mental illness.
Okay,
So in
like
this case,
schizophrenia.
and they may very well, I wouldn't necessarily just assume that they didn't think to argue incapacity.
No, for sure.
They may very well have then weighed up those two defenses to the homicide with murder. And the only difference between the more serious offense of murder and the acquittal for murder says, I genuinely, sincerely was mistaken. So
Right. This is for putative.
This is for putative. So I mistakenly believed that person's to argue it.
I didn't know that you still had to deal with culp.
Yeah, you do.
But then that goes down to the negligence issue.
So it goes down to negligence, but because it's a putative defense, it also goes down to the reasonableness of his belief. It's not just his conduct.
Yeah.
You know, negligence generally is just his surrounding circumstances. So, for example, the reasonable driver stung by a bee, if that person had been stung by a bee,
Okay.
right? but you do not take the accused's internal characteristics in, is a prime example of that.
The tragic, the traumatic assault.
Absolutely. What happens, so yes, if put Meryl Foster on the stand. I mean, I've been quite stupefied by some of the people claiming to be defense lawyers commenting on this case.
Yeah.
I mean, one of them I found out, I don't understand. If this isn't evidence for incapacity, then why have you been brought onto the stand? I don't know exactly why of a prosecutor ever arguing for Section 78. It's a defense.
Yeah.
Section 78 is a defense. I mean, it's too hard to actually judge how the case has gone because we don't know. Maybe he's the last person coming on the stand still.
I thought the pathology evidence was quite similar. They seem to agree on quite
strategies.
Yeah.
So there's a number of strategies that it can play into, but in terms of that strategy,
you deserve to know more.
eNCA.com